Thank you.
Next case on the docket is Williams versus State.
May it please the court, my name is Valerie Lennon and I represent the appellant Jeremy Shea Williams. At this time, may I reserve 2 minutes for rebuttal? There's only one issue before the court today, and that's whether the trial court abused its discretion by allowing 2 law enforcement officers to testify on rebuttal who were not eyewitnesses to the crime, that they could identify Mr. Williams from the surveillance video because of their long history and contacts in the community through their official duties as law enforcement officers.
We can all agree that the case law is pretty clear. The law enforcement officer cannot, a law enforcement officer can make an identification in some cases based on a video, but they cannot disclose to the jury during their testimony that they are in fact law enforcement. I think that we can all agree to that.
Correct.
The question here is whether the defendant, through his testimony, opened the door to allow the state to come back and then bring the officers back in and let them tell what they did for a living so they can give some sort of context, I suppose, on how they knew the officer. And that's the real question. What I wanted to know is, based on the fact that the defendant got up there and testified that he is, and part of the reason for not allowing the law enforcement to testify is because it gives some sort of impression to the jury that there have been prior contacts with law enforcement leading to, evidence of prior bad acts, and that's the reason why it's prejudicial. Here, though, the defendant on the stand acknowledged that he had 4 prior felonies. So the fact that he acknowledged his prior record while he testified, would that eliminate any potential harm that might be caused by the officers getting up there and testifying that they weren't that law enforcement?
No, Your Honor, because he didn't disclose the nature of the felonies. So even though he admits, I have 4 felonies, the inescapable conclusion when these officers reveal on rebuttal that they're law enforcement officers, that they've known him for 10 to 12 years, seen him 2 to 5 times a week conducting foot patrols in the community, was that he had it was as a result of prior criminal conduct.
Weren't the officers very careful to limit their testimony? I mean, they talked about being in the neighborhood and interacting with people in the neighborhood. It seemed to me they went out of their way not to say specifically how they had the interaction. For all the jury knows, it's because they walk the neighborhood every week, right?
Well, Your Honor, if they're patrolling a neighborhood by foot 2 to 5 times a week, it's not because it's a nice neighborhood with no crime. If they're patrolling by foot, there's a need to patrol by foot and create relations in the community. Actually, the Second District addressed a similar situation in the Alcantar case, where the officer testified that he knew the defendant through his many years of law enforcement experience in the community. He had prior contact with the defendant for years, and he knew the defendant by his street name. What the Second District held was that the inescapable conclusion was that this was through prior bad acts or the result of criminal activity. And that's what we have here on rebuttal, that they they had 10 to 12 years of law enforcement experience. They knew Mr. Williams through their contact 2 to 5 times a week in the community on these foot patrols. And then they one of them testified that they knew him by his street name of Haitian. So the inescapable conclusion of that is that this was of prior bad acts, prior conduct. Even though he had 4 felonies, they could be for he didn't disclose the nature.
Bad guys have street names? Is that what you're trying to say?
That's when you...
Having a street name means you're...
I don't have a street name. I mean, that's the suggestion. That's the inescapable conclusion from the jury. So they're in a community and they're out 2 to 5 times a week in this community. They don't patrol on foot in communities that don't have crime. So if he's got a street name, that suggests drug activity or other criminal acts.
Street name, just another name. I mean, some of us call it that a nickname as opposed to a street name. I mean, it's sort of...
Gosh, I gotta think there's a difference between a street name and a nickname.
I'm a criminal because I have a street name versus, my nickname is Haitian or PlayStation Haitian or whatever.
Sure, Your Honor. Your Honor, actually, and the street name came out in the state's case in chief, so that would have been okay if it was just that. But then when you couple it with the fact, yes, we're law enforcement officers, yes, we know him through our official duties as law enforcement officers, we've encountered him this many times over this many years, and we know him by a street name, then it becomes the inescapable conclusion by the jury that he's done prior criminal conduct, and there's no amount of limiting instruction.
But he's already testified by the fact that he took the witness stand. I mean, he testified through direct examination by his own counsel, which is a smart thing to do, to get it out there in the open in the beginning. Testified that he was a 4-time convicted felon. So, I mean, it's already out there that he has a criminal history.
Right, and that's part of it. But the other part is that this video is highly indiscernible and it's inconclusive. So if the jury for themselves, after watching the video, I'm sure they did because we all have, if they couldn't conclude for themselves whether or not that was Mr. Williams in the video, then the law from this state is pretty well settled that they are inclined to, that it runs the risk that they will defer to what they view as these officers' experience and training or information not admitted into evidence at trial.
If anything, if he testified that he'd been convicted of 4 felonies and the officers testified about hundreds of contacts with him, if anything, that would indicate that the contacts weren't necessarily related to bad acts if he only had 4 felonies, right? Out of hundreds of contacts? They must have had contact
Correct.
with him separate and apart from criminal conduct.
Correct. And what the real problem with that is that Mr. Williams testified that he had an alibi, that this was not him. The blood on the door was found because he nicked himself installing tin. So the real problem is that the jury would be inclined to believe the officers over Mr. Williams if they thought he'd been involved in bad acts before.
The basis of the general rule that they can't testify to this is the basis that the prejudice outweighs the probative value, right? It's not that it's
Correct.
irrelevant, it's not but it's the balancing test, right? And
Correct.
the prejudice outweighs the probative value. Doesn't that inherently make it fact-specific then? Because in particular cases, perhaps this one, the probative value is more significant than it is in other cases because of what other testimony was provided. So
Correct.
we can't really make a bright line test that says it's always out, and if it's going to be a weighing test, we give an awful lot of discretion to the trial judge, don't we?
We do, Your Honor, but if we'll look at it, if we'll look at what happened on the case in chief, I believe it was Officer Barrio said, I've known him for 10 years, I know him by a street name of Haitian. And then Officer Bauer said, I've known him for 10 to 12 years. I recognized his voice because I didn't recognize his face in his video, just that he said something about tripping, and they recognized that was something that Mr. Williams said. So we have that testimony. Mr. Williams says, I don't know them. Well, that right there was enough for the jury to make a decision. Do we believe these 2 men, or do we believe Mr. Williams?
To explain in detail how you know him, if his testimony is going to be, I don't know these people, I don't have a clue who these people are. Isn't it certainly relevant and probative at that point to say, of course he knows who we are, let me explain all the details of how we know him?
Well, relevant and probative, maybe, but it's still unduly prejudicial. So under the concept of opening the door, that testimony is only allowed in 3 circumstances: to qualify, to explain, or limit. And it's not just that Mr. Williams said something that was misleading, or it was an incomplete picture. Fairness has got to, it's the main concern. It's principles of fairness that govern under opening the door. And fairness here says that that testimony was unduly prejudicial. The jury had everything they needed at that point to make a decision, to weigh the conflicts of the evidence. I believe that's jury instruction 3.6F. Reasonable doubt can be created through conflicts in the evidence.
What if the basis on which the officer knew him was that he had spent 8 hours in an interrogation room with him? So obviously the guy knew him, he'd spent this huge amount of time with him. And he says, I know him, and the defendant says, I don't know this guy, I've never seen him before. Can't the police officer in that context say, yes, he knows me, I spent 8 hours interrogating him in a case? Isn't that more probative than prejudicial?
Sure, it would, but that would fall under the second prong, which is explain. This is how I know him.
Isn't
And
that
this is
what
why.
happened here? They were explaining how they knew him, by walking the neighborhood, talking to him in the neighborhood. Why is it any different?
Because the difference being, when they testified during the case in chief, was we've known him 10 to 12 years, we know his voice and we know his street name. Now, on rebuttal, we throw in there, we are law enforcement officers, and we know him through our official duties as law enforcement officers. That's where the real prejudice,
Because he
the
said,
undue.
he doesn't know me at all. So now I get to explain.
I get to explain.
Why you can't believe him when he says he doesn't know me at all, because I can tell you about 47 times that I talked to him. But to explain the 47 times I talked to him, I've got to give you the context, which is I'm a police officer.
And then the overall governing concept of fairness comes into play. Is it fair to the defendant to have these officers get up and say, we're officers, we know him through our duties as law enforcement officers? And then we look at the context of everything that they've testified to, and then it becomes unduly prejudicial. So maybe not this little part, this little part, this little part, but when we put it all together, then it was unduly prejudicial.
Do you believe that the door was opened?
No, I don't.
Why not?
The defense counsel said it best. He said that, the jury had already heard enough through the testimony to make their decision without adding this gratuitous testimony on top of it. And if there are no further questions, thank you.
You have about 4 minutes for rebuttal.
May it please the court, my name is Ann Phillips. I'm here on behalf of the state of Florida. The state agrees that had that testimony come out, the officer's testimony come out on direct examination, the state's case in chief, we'd be having a different conversation. But the defendant himself, by his testimony, made the officer's rebuttal testimony relevant.
Well, how is it, I guess when I'm going through the testimony of the defendant on cross-examination, is it your argument that he basically said, these officers don't know me, I don't know them?
Yes.
Because that's really not how I read the testimony.
One of them, it's basically, he doesn't know me, I don't know him. The other one was, he doesn't know me, he thinks he knows me, he knows about me from the community, but I don't know him.
I'm reading from page 527 of the transcript, which is the testimony. You do know Todd Bauer, don't you? Answer, I probably see him around. I don't know Todd Bauer, but you've got the defendant admitting that he's seen him around. He's the one that identified you and he recognized you, so he's known you and you've known him for years, right? He talks about the video. But he says, Todd Bauer don't know me. Todd Bauer just know what he hears off the street, sir. No, he knows you, and he says he does not know me. He's probably seen me, but he does not know me. So you've got the defendant here admitting that the officer has seen him. And he says, sees you once or twice a week for years. And the defendant says, and that don't say that he remembers me. He's got a lot going on in his life. So he doesn't deny that the officer has seen him once or twice a week for years. Well, he says, I can't agree to that. There was a question, would you agree he's seen you once or twice a week? He says, well, I can't agree to that. But he's not indicating that the officer has never seen him. And then with regard to Officer Burial, he says, well, he says, he knows you, doesn't he? And he goes, no, well, I don't know him. So I'm having a little trouble with opening the door here based on that line of questioning. But let's say that he did open the door. There's got to be some sort of legitimate need for the officers to come back and, or for the state to present this type of evidence. Case law says it just doesn't come in because there's been some sort of conflict on direct, that the state has to show a legitimate need to get this evidence in. So what legitimate need did you have in order to resort to admitting the fact that these individuals were actually law enforcement officers? I mean, what was the need there to present that evidence?
To explain the defendant's testimony, to rebut his testimony that their identification couldn't have been solid because they don't know him that well, they haven't seen him that much, they didn't agree that to the 1 to 2 times a week. The defendant knew as well as the officers what their conversations had been over a 10-year period, and yet he chose to testify that no, and he tries to downplay it. From the beginning, from the state's opening,
Downplaying something isn't a direct conflict in testimony. I mean, downplaying something is, ultimately, then the jury can decide, but, I don't see in this testimony a direct denial of ever knowing or seeing either one of these officers. Basically, the complete testimony.
the state's case, I agree to the point with Officer Bauer that it was much more of a hedging, but when they asked about direct testimony, he said, I'm not in that video, I'm not in that video. He didn't answer the question that was asked. You've seen the video, it's not me. And then when it was burial, he did deny. He said, I don't know him, which certainly stays, he doesn't know me, I don't know him. How could he have seen me enough to identify me in that video? And if you look at the video, it's not clear to someone who doesn't know the parties involved. You would have to know somebody to be able to identify him. That's exactly what the officer said. I've seen him in profile, I recognize his voice, I recognize his verbiage that he uses.
They did say that without revealing the fact that they were law enforcement officers.
Yes, and in order to rebut the fact that the defendant made it seem like their statements were false, that's what rebuttal is, to be able to rebut what his statement was, to explain how that statement was untrue. And that's what they did here. Regardless, it would be harmless in this instance. He admitted he's a 4-time convicted felon. The whole purpose of not revealing you're a police officer is to not indicate that there were some sort of prior contacts. There were obviously prior contacts. He's a 4-time convicted felon. So the cat was out of the bag with the defendant's own testimony that he's a convicted felon. His DNA was in the car with the blood that was convicted, the car that was used in the drug deal. The fact that these officers testified they were officers on rebuttal is not what sealed the deal for the defendant. The evidence against him was. So even if it didn't open the door, the testimony was harmless at worst. If there are no further questions, we'll rely on our brief and ask you to affirm. Thank you.
May it please the court. The state just argued to the court that it was harmless that it came out that these officers were law enforcement officers on rebuttal. But then that goes back to, and the case law on this is really well settled in this state, that if the jurors, in viewing a surveillance video or viewing photographs, if they cannot discern the identity of the person depicted in the video, then they will defer to the officer's judgment, to their experience, to their training, and to what they perceive as background information not admitted into trial. That's Martinez versus State from the from the Florida Supreme Court, and most recently Alvarez versus State from the 4th DCA in January of 2014. That's the real harm. And this video was inconclusive, it was indiscernible. Like the state said, if you didn't know somebody in the video, you wouldn't be able to tell who the driver is. That's the harm.
You've got the defendant's DNA in the car, on the driver's side. And then you have the testimony of the officer that was engaged in the transaction, and admittedly, he couldn't ID him. And then you have the defendant testifying that he has 4 prior felonies. So we have to weigh that.
As well, yes, you do have to weigh that as well, and so did the trial court and the jurors. But again, that goes back to, do we believe him because he's been in trouble, or do we believe them because they're law enforcement officers? And that's the real harm here. If there are no further questions, we'd ask that you reverse. Thank you.
Thank you, counsel.